Good afternoon, everybody, and it is a pleasure to be here in Delhi to address you this afternoon. Thank you for the warm words of introduction. Just a very brief word about the perspective I am seeking to bring in my opening comments. For those of you who have read my introduction, I am a barrister who has practiced in antitrust law for about 2 decades now. But it's not only the external lawyer perspective that I'd like to share with you today. Throughout my career, I've been involved in academia and have written on comparative perspectives on antitrust, both in Europe and Asia and internationally. I've worked as a director at PricewaterhouseCoopers in economics, so I'm informed in my comments from that perspective. I like to say that I have gone about my career building up legal experiences and related ones through authorship of books and representing clients. I think that the only exposure I haven't had to the different perspectives is as the decision maker in court yet, but all nominations are greatly received. In terms of the balanced perspective, though, I'd like to turn this upside down and really ask ourselves, or pose the question for this concluding session, as to which policy instrument in terms of antitrust regulation or sector regulation is best suited to really promoting innovation, which has been one of the guiding themes of this conference. And I use that as an anchor point because there is often a tendency to contrast in quite diametric terms the role of antitrust as the correcting mechanism, as we've had in our introductions, to intervene ex post once we observe a harm, whether it's an abuse of market power or anti-competitive agreements. And that's often contrasted with sector regulation, which intervenes ex ante or before the event, before we observe excessive pricing or refusal to supply IP rights, almost to safeguard against those aberrations happening. And I'd like to pose the theme that perhaps these are not so diametrically opposed opposites as one might think. And if we look at the relationship between market power and innovation, here's a very oversimplistic diagram, and apologies for any economists in the room that this may be somewhat oversimplistic. But the idea being fundamentally as a given that we reward innovation and investment through the promise of exclusive rights, whether those are granted by the state in terms of a limited right to exploit a patent for a period of time, or copyright to prevent others from copying a particular representation. And the idea there is that we sacrifice some form of dynamic competition, we balance it against static competition, and we reward long-term investments. And it's interesting that the General Court in 2004, when looking at Microsoft and its refusal to license its interoperability information, looked to the balancing exercise of the incentives to innovate on the market, not just the party that was accused of abusing dominance. So they're recognising the quid pro quo, but certainly no easy task. We've said a lot this afternoon around innovation and investment in so-called high-tech markets. Mobile phones, search have been prominent features. But I'd like to take a sidestep and think about perhaps the fintech sector. And the particular insight I'd like to bring there is one very close to where I have travelled from over the past 2 days, which is the United Kingdom, where we have had payments innovation and competition very much in the news. And this has led to the development of a particular regulator that's charged with the narrow remit of regulating the payments sector. And it's fair to say that that is unique internationally, and it's rare that such a bold claim is made. And I've been involved in supporting that new regulator, a nascent regulator, develop its own regulation. I did some work with CCI and have written extensively about that when India's new competition regulator was established. But certainly now it would seem a grandfather compared to this nascent regulator. What's interesting about the payments regulator is that it has ex-ante sector regulatory powers to promote competition, contrast with a competition authority that would generally intervene to protect competition. But it also shares the power with our competition authority to also apply competition law ex post. On the innovation side, it also has a proactive, forward-looking responsibility to promote innovation. And this has given rise to many tensions, because at one side, payments were born competitive. They're not traditional monopoly industries. We pick up our mobile phone. We've got Apple Pay on there. We can make a payment for a coffee from a mobile device. All of this grew up without any structured regulation. But at the same time, there are suppliers in the industry that control the distribution, the pipes and the plumbing, the infrastructure. BAPS, CHAPS are all the infrastructure over which payments are delivered in the UK. So we have a very uneasy equilibrium between monopolistic characteristics but a free market. And just some early concluding themes that I would like to leave you with from my opening comments, that as an antitrust lawyer and also someone versed in sector regulation that has seen it from industry, economics and academic perspectives, I would pose the theme that where competition is feasible, it's usually the most effective way of promoting innovation. Where that has shown to be broken down, regulators have stepped in with their own vision of innovation. And I do ask myself whether that is preferable to letting industry decide. Because if our concern is of a monopolist imposing its vision of innovation on the market, what is preferable about a regulator doing that? And I'm sure that views will differ. And perhaps one early insight from the payments regulator has been industry resistance on innovation, but again, accepting that that there does need to be collaboration rather than competition in some areas to really deliver long-term benefits. So a few thoughts there to take away. Similar to mobile phones in some respects, but quite a unique test case and one which hasn't yet proven itself. Thank you.
I think Professor Lanos, while he comes up, because Susan quickly mentioned CCI, I must put it on record. I have never seen this happen in India, at least. This is the first panel where there is not one, not two, but three CCI officials, one current and two ex. So, we can have a lot of good insights.
Himself or himself?
Thank you very much. I'll change with this. Yeah. Okay. So thank you very much for JIRICO for their invitation. It's a great pleasure to be in Delhi. So I will actually, in my 6 minutes of fame, I will actually touch upon the broad topic of digital economy and competition law, basically introducing a little bit an issue that I have with the way actually things evolve, which is this opposition we usually make between markets and platforms, right? And see if this could be relevant for our discussion. So what actually we have been witnessing the last couple of decades is a great transition from the internet and the rise of e-commerce to basically PCs and smartphones and tablets becoming, the main tool, the main devices with which we interact on the internet, and then slowly we move towards the era of Internet of Things and big data. And to a certain extent, these are different manifestations of this digital or informational capitalism that we have seen, where the very important element is data. Data is actually the new oil, according to some. And in this important transition that doesn't necessarily only happen to one sector. We cannot actually say that there's a digital sector. Actually, this is a revolution that touches upon all sectors of the economy. We have seen the rise of tech companies. So if you look, for instance, in terms of capitalization, at the 5 most important companies back in 2001, only one actually was a tech company, Microsoft. If you look to 2016, basically all of them are tech companies. And I will say all of them are American, US-based tech companies, and I will come back to that in a moment. And what is actually also interesting is that all these 5 companies that I mentioned before are platforms. All right, they actually take this form, this business form, which basically platforms are matchmakers. They try to put in contact different groups of users. Their main focus is to promote transactional efficiency to a certain extent by making possible transactions that won't happen if these platforms were not there. And these platforms, as I will show you in a moment, have very different business plans. So some of them charge one segment of the market, one side of the market. Some of them charge both sides. Some of them are actually having a different perspective. And we see all these platforms present in various areas, in various economic sectors, in transport, accommodation, ads, savings, game playing, etc. So here you have a list. Now, why are platforms taking over? Why actually these tech companies and platforms are taking over? The first reason is network effects. So direct network effects or indirect network effects, these large economies of scale that somehow increase profits exponentially. And that leads to a winner takes most world. So much of competition happening right now is not really competition in the market, but actually competition for the specific market. Basically, companies trying to get as much scale as they can in order to basically win competition in this context. And that leads to very concentrated markets where you have the top company that has really higher sales and profits than the second company. Then the second is twice as large as the third company, and the fourth and the fifth company actually are irrelevant. So this is the kind of market configurations that we have. And that is somehow intriguing for competition authorities, because usually competition authorities, when they see concentration, they somehow become a little bit worried. I'm not saying that, we should focus only on concentration. We should also look to the theory of harm and the possible effects to consumers, but concentration is the first step in the analysis. Now, the second reason why why these platforms actually have high profits is that they have much less fixed investment and fewer employees than traditional companies. So for instance, if you look to the chart there, BMW, actually over 100 years old company, has 116,000 employees, and Uber, which basically is a few years old, has 7,000 employees. They basically have more or less the same market capitalization. And you can look to that with regards to Marriott, a hotel chain, and Airbnb, Walt Disney, and Facebook, or Kodak and Instagram. And also to a certain extent, these companies have low fixed costs, fixed investment costs. They have lower levels of employment, and therefore, higher basically profitability in terms of the capital. And obviously, this market configuration leads to the emergence of the so-called dataopolis, where harvesting data becomes extremely important. And obviously, we as consumers are pretty concerned about these competition about harvesting data, because actually we want to protect our personal data. And many competition authorities have been thinking about introducing or including privacy as a parameter of competition, or as an element to define quality, let's say, in order to implement competition law. There have been interesting cases. For instance, in Germany, there's this recent Facebook case, which I think would be quite interesting from that perspective. Now, of course, that leads us to the problem that we don't really have metrics to assess the way we assess price effects. We don't have metrics to assess quality effects. For instance, if we look to privacy, there have been different proposals made. Some people suggest to use contingent valuation methods or conjoint analysis. I mean, that is something that has been used, for instance, for other types of concerns, like environmental concerns, in this recent Dutch cases, the chicken of tomorrow cases, etc. So I think it could be interesting to see, what these type of methodologies might bring to the analysis. Then, at the same time that we have these problems with concentration and high profits, we also have the geopolitical problem, in the sense that if you are a European policymaker and you look to the geography of platform businesses, well, you see that Europe is basically very much behind. Most of these companies, the big platforms, are basically based in the US or in Asia. And that, to a certain extent, leads the regulators to think about probably ways to use competition law possibly for strategic purposes in this context. So, for instance, we have seen, one might consider the policies that the EU is adopting with regards to extraterritorial application of data protection regulation, or the new regulation concerning platform-to-business relations, as a way basically to at least be present and somehow limit the power that US-based or Asia-based platforms have on the European consumers and businesses. And the other, I think, complexity that is added by digital platforms is this interaction between the economy and the politics, right? And we have seen that with the Cambridge Analytica kind of scandal recently in the UK. So to a certain extent, they're too powerful, and they're quite influential with regards to politics. And to a certain extent, one might need to think about what is a competition law there also to take into account these economic democracy concerns. I mean, there are voices towards that direction. So we see basically the end of markets as we know it. And to a certain extent, markets are extremely important. Why? Because markets are there to reward productivity. It's the best way, basically, to reward productivity. But if you move to platforms and where network effects are playing the most important role, then, you may have a problem, because even if you have a better product, well, if you don't have, you don't have access to this value chain, to these networks, even if your product is better, you're actually not going to be rewarded for it, right? So, and I think from that perspective, it really changes the way we can think about competition law in markets in general. So as I said before, there are various, business models here. Here are this Xbox, where they charge both sides. Netflix or Google, actually, they charge basically one side, and the other side is free. Uber collects data from users and pays drivers. Windows collects from users and subsidizes apps. So we have basically very different type of models. And the question that competition authorities and courts have is, how can we address competition concerns in the platform world? We have actually the recent Amex case of the Supreme Court, where basically the court tells us that we don't really have to care only about one side of the market, let's say the merchants that are paying the fee for Amex, and where there was evidence, clear evidence that the fees have been increasing, right? We have actually to look to the other side as well. And if you really want to bring a case, you have to prove a net negative effect, basically in both sides, right? Which makes life very difficult for plaintiffs. Why is that? Because according to the court, platform is basically, transaction is the unit, and platform is basically the unit of analysis rather than market, right? So we move from relevant market to platform. One might criticize this approach. One might say that the European approach that we see in the carbon care, for instance, is better, in the sense that you are addressing competition and the competitive effects at the market level, but then you can also do a rule of reason analysis by including possible positive effects that you may have on the other side of the platform. These are important choices to be made by various competition law systems, right? So that's, I think, the first issue. The second issue is that what changes is that consumers, because we talk a lot about consumer welfare, are not really at the end point of the data value chain. They are also the input. Because consumers and their data is the raw data is the input that is used in the input-output process that leads to the monetization of this data, either in data markets or actually in-house. So that, to a certain extent, changes completely the way we think about the data, the value creation in this context, and what is the surplus of that value that goes to the consumer, right? And the third thing is the important role of financial markets. I mean, that's not something that we see only in tech companies, but more generally is the process of financialization, as Sam mentioned, is that quite a lot of the value of these companies is basically not based on net cash or profits, but on future expectation of profits. And here, actually, I put this interesting chart from The Economist, where basically you can see that 95% of Amazon's value was basically based on profits that could be made after 2020. Now, why is this important for competition law? Because actually it leads to the somehow incentive for CEOs to develop, let's say, very aggressive merger and acquisition policies, buying potential competitors, showing that they are, they're becoming sort of mega utilities that could possibly develop bottlenecks in the future, and therefore, to a certain extent, become indispensable, right? And that is a building, then this narrative is built in order to convince the financial markets that, our value is very, very high. Please get our stocks, all right? So, and I think that is something that we also need to integrate in competition analysis, this futurity that we see in the way financial markets work. Now, final point, and I know I'm a little bit running late. What we can do as competition lawyers to deal with that? I think that we might have different approaches across jurisdictions. Some of them will be more permissionless innovation approach. Well, innovation will come. Bottlenecks that exist now will disappear. Let's leave the markets work. The platforms, actually, not the markets, work. You may have the other side, which is a principle of precaution. And I would say the EU is probably representing that in a sense. Well, it's better to intervene early before these bottlenecks are basically formed. The problem with that approach is that competition law is very slow, and even if you try to intervene early, when you get the final decision, it's probably too late, right? And the remedy. So maybe more use of interim measures in this context, in these markets. I mean, that's kind of an interesting issue. And then, you might have experimentalists. approaches, which I think is very important to have. So from that perspective, I'm in favor of having divergent approaches around the world. I don't think convergence is a good thing at this level of development of digital capitalism. I think we need to try different approaches and see what is the best one. And obviously, we can actually have different approaches according to various areas and sectors. The other thing I think is very important is not to focus only on horizontal competition, as we usually do. Competition, let's say, by existing rivals or substitutes or potential entrants, but also take into account what has been called vertical competition. So the competition for rents of the surplus value, the total surplus value, that comes out of suppliers or buyers, and these buyers might be even consumers or users, right? And in order to map better the various competitive interactions that happen in these markets, I think it's very important to develop tools that are different than the classic relevant market tool. And here I suggest the value chain tool. I mean, this is very, very kind of simple chart. I mean, there can be much more complex ones where we try to map better, to a certain extent, the competitive interactions between the various firms and the various elements of state intervention. So, for instance, usually, when we try, for instance, if we take the Google case, we're focusing on applying competition law on the search engine, right? Because of this leveraging a practice that Google might have tried. But at the same time, I think taking that approach and including also all the other important players in this value chain and all the other forms of intervention, for instance, through net neutrality with regards to internet service providers, or through compulsory licensing, or maybe try to think about collective bargaining of users vis-a-vis these platforms in order to get the better deal concerning the use of their data. I think this is the kind of approach that we really need to take, and this more holistic perspective. And I think just focusing on the market, or relevant market, is not enough. I'm not criticizing relevant market as an important tool. It is very important. It provides focus to the inquiry, but at the same time, just focusing only on that and not having the big picture might be very problematic. And the final thing is that, and I've heard the term ecosystem quite a few times, actually, since yesterday. I do think that there's quite a lot of work now in business studies about a theory of ecosystems. There are many interesting people writing on that. Michael Yacovidis, a colleague of mine, is writing on that. And I do think that these ecosystems and the way actually the cooperation and competition basically is organized within the system is a very important element that we need to take into account. So maybe, in addition to the value chain approach, we might also think about an approach that takes into account these ecosystems becoming a concept of competition law. I won't stop here because I'm already, I think, quite late in my remarks. Thank you very much for your attention.
Hello, my name is Wendy. I'm from Melbourne University, and today I'm going to talk to you a bit about the role of competition law in promoting innovation and taking the Chinese perspective. I've heard today from a number of sessions that you guys are quite interested in what China is doing in this space, so I thought I'd give you a bit of a background. So in my remarks today, I want to briefly canvass the following issues. At first, I'll outline some of the reforms made in China to strengthen the protection of intellectual property rights. Then I'll fit that strengthening of IPR into its broader context, and then discuss how competition law fits into this context and what is its role in promoting innovation. So first, there is a common perception about IPR protection in China, is that it generally doesn't exist. But in actual fact, in the past few years into a decade, China's taken a series of significant and concrete steps to strengthen the legal protection of intellectual property rights in China. So, for example, reforming the IP and litigation and judicial system. It's currently revising its patent law, and it's including introducing punitive damages of up to 3 times a complainant's losses as a way to deter. And it's also establishing more IPR protection centres. And China's also undertaken administrative restructuring to reinforce this increasing legalization of IPR protection. So most recently, the State Intellectual Property Office, SIPO, it used to be supervised directly by the State Council. State Council is China's equivalent of its cabinet. And now SIPO will now be instead supervised by a newly established market regulator called the State Administration for Market Regulation. This is a more general market regulator of markets as a whole. So it gets to see, I guess, a more macroeconomic perspective of markets. So that's a first administrative change. The second is that the SIPO's scope of responsibility has expanded as a result of this government restructure. So before the restructure, it used to be responsible for patents, but now it's also got trademark responsibilities and also geographical indications of product origins as well. So now this SIPO handles both patent and trademark matters. So why is China strengthening its protections of intellectual property rights? Actually, this increasing legalization and protection makes a lot of sense. First, as more and more Chinese companies themselves create and apply for IPRs in China and overseas, they will demand more effective IPR protection from the Chinese government. Now, these increasing IPR protections also benefit foreign companies who have long complained about ineffective IPR enforcement in China. So this legalization of IPR protection caters to both a domestic market and also the foreign market as well. The IPR system is also seen as fundamental to supporting innovation and development. So strengthening the system helps to further these strategic policy goals. Now, China's goal for 2020 to 2035 is to develop into an IPR powerful nation and to enable IPR to become the engine that drives China's innovation. And innovation is also a key part of Made in China 2025. I heard a few references to Made in India. This is Made in China 2025. It's an industrial policy program aimed at, improving manufacturing, etc. So, there are a number of good points and reasons why China will choose to strengthen its IPR. But is this increasing legalization and protection all good news? Now, the effective folding in of SIPO and therefore IPR protection into the market regulation apparatus confirms that intellectual property rights are seen as instruments of market regulation in China. And effectively, it helps to further the state's interests in that regard. So instead of viewing IPRs as rights that protect private property, it is an instrument of market regulation. So when you're talking about IPR enforcement and protection, the protection of property rights may not be the main consideration in IPR enforcement cases, especially those that are contentious or those that exist in sensitive industries or industries that are earmarked as important to China's state interests. So what we would generally expect to form the foundation of reasoning behind these decisions may be different. And as with all instruments, this can be a double-edged sword. So foreign companies can now more easily enforce their own IPR in China, but Chinese companies can also do the same vis-a-vis foreign companies. So how does competition law fit into this environment? Well, the Chinese competition authorities have viewed intellectual property as essential for innovation and technological advancement, much like the other parts of the government. So they see anti-competitive abuses of intellectual property rights as stifling innovation, and that high licensing fees and unreasonable licensing terms don't encourage R&D. So the Chinese competition law has been implemented in a manner that reflects its role in promoting innovation, both in the context of development and also in industrial policy. So a number of merger and abuse of dominance cases have dealt with, as their key concern, intellectual property rights and the terms upon which they are licensed. So the merger cases have involved foreign companies that were operating in the communications and technology sectors, and they held key IPR, so standard essential patents, that are required to access these industries. And the Competition Authority was concerned about the terms upon which these intellectual property rights licenses were being granted to smart mobile phone device manufacturers and other downstream businesses. And it's no coincidence that many of the main manufacturers of these devices are Chinese companies. So their concern is essentially, how do Chinese companies access these IPRs? And to address these concerns, as part of the merger approval process, the parties were required to license IPRs on a FRAND basis and to maintain existing licensing practices. And there have also been abuse of dominance investigations, very high profile, against Qualcomm and InterDigital that also concerned IP licensing practices and the fees that they were charged. And the parties offered commitments to these authorities to address the licensing concerns, and they also made commitments about the level of licensing fees to appease the Competition Authority. So through the enforcement of competition law, the agencies were able to secure commitments on IPR licensing and therefore access to these IPRs for Chinese companies. And this has been a source of criticism by commentators who feel that sometimes the anti-monopoly law is undermining the foreign companies' intellectual property rights. Now, beyond enforcement, from a policy perspective, the agencies are formulating an antitrust guideline that applies specifically to the anti-competitive abuse of intellectual property, and it is expected to be adopted soon. Now, do these recent changes to strengthen intellectual property protection impact on how competition law might be applied in the future when dealing with intellectual property rights? So, as part of the same government restructure, the competition enforcement agencies were also consolidated into the same state administration for market regulation. So now, competition enforcement and IPR protection are under the same agency. So what does this mean for enforcement of IPR and enforcement of anti-monopoly law? It does mean this. First, both intellectual property rights and competition law are key aspects of markets in China and also instruments of market regulation and supervision. There is a potential to decrease the potential conflict that can arise when you're talking about exercise of IP rights, the enforcement of IP rights, and then the abuse of IP rights. Now, the key reason for establishing the new state administration for market regulation was to enhance enforcement efficiency and consistency. So it's not inconceivable that there will be greater enforcement coordination within this state administration for market regulation between SIPO, the patent and trademark regulator, and also the Anti-Monopoly Bureau when it comes to issues relating to IPR. So I'll leave it here. If you have questions, you can ask me later on. Thank you.
Good afternoon, everyone. I'm very happy to be here to share some information and ideas with you. For China's anti-monopoly law, this year has its special meaning. On the one side, the anti-monopoly law has enforcement for 10 years. And on the August 1st, China just celebrate its 10th anniversary of this law. On the other hand, from the beginning of this year, Chinese anti-monopoly enforcement authorities had a great changes. That is, the three enforcement agencies has been integrated one, the SAMR, the State Administration for Market Regulation. For 10 years, China's anti-monopoly enforcement has made great progress, both in administrative side and in judicial side. But Chinese anti-monopoly authority faces a lot of challenges. Among them, this topical anti-monopoly challenges in the area of the digital economy is typical and then obvious. So in following, I will discuss this topic. In the past 2 decades, the rapid development of China's internet industry and technology has led to the rise of a large number of data-driven internet companies, such as Alibaba and Tencent. At the same time, the government attaches great importance to the industry development of big data and AI, and has formulated relevant policies. But developments of digital economy are inevitably accompanied by some problems, including monopoly concerns. When internet and data become strategic resource for corporate competition, monopoly concerns are also receiving much attention correspondingly. There were a series of incidents related to internet and big data, such as the case of Qihoo and Tencent, Dianping and Baidu, the Cainiao and Shunfeng, WeChat and Huawei is the representative. In the application of the anti-monopoly law in digital economy, challenges are faced. There are some examples. The first, review of data concentration. In case that data is monopolized by a single enterprise, it will not only reduce industry innovation and consumer bargaining power, but also trigger huge threat to information security. But it is insufficient to just rely on post-regulation and law enforcement. Prior review of merger and acquisition also faces many problems. For example, the DD, which has already been a giant in the big data market in China, after it successfully acquired Uber, but have not yet reached the report standard according to the anti-monopoly law. The second, big data and corporate conspiracy. Monopoly agreements have different manifestations and behavior characteristics. Big data helps to improve market transparency or enhance the interdependence of business operation between companies, thereby encouraging conspiracy. Companies can use the same specific pricing algorithm to coordinate pricing and some other examples. Conspiracy based on big data is crazily hidden and then technological, which presents a great challenge to law enforcement authorities. The third, big data and enterprise market power. More and more data-driven enterprise reach data concentration through measure and acquisition, but it was observing in depth that whether market dominant position can be directly concluded for an enterprise just because it achieves data concentration. If a company which owns strong database or builds a platform to collect data and make access to data, abuses its data advantages in the course of market transaction, it may thereby lead to concern or even intervention of anti-monopoly law enforcement agency. In China, recent news about big data friend advertising or friend hacker has received great concern and hot discussion. This is related to an internet giant, C-Trip. Briefly speaking, all the customer face the price discrimination compared with the young, new customers. So it raises extensive discussion in China. Currently, the basic framework established by China's anti-monopoly law can still be applied to the competition in the field of digital economy. But it is necessary to explore and work out specific problems in accordance with the characteristics of the field itself. Facing challenges, China is speeding up its legislation in the field of data and artificial intelligence to regulate the content and the forms of the sharing data resources and establish a comprehensive governance system to provide fair, equitable, safe, and reliable environment. In the meanwhile, China is also strengthening the international exchange of research in big data and promote the sharing and transformation of research achievements. Thank you very much.